What's up? What's up? So you got one person in here. Guess we'll be starting in 1 minute, 7 o'clock. We're about to be going over how to attack standing, what exactly is standing, how to attack authority and what exactly is authority. And then we're going to talk about jurisdiction. You got different forms of jurisdiction. You got personal and subject matter. So that's the topic for today. And we're going to talk about how to properly address these issues when you have a debt collector or original creditor coming after you in court for a debt. Yeah, yeah, yeah. So, yes, we just get it rocking. One person was in here. That's about it. So, standing. Excuse me. Was one person in here and they rolled out. Yeah, yeah, yeah. Ain't nobody up in here yet. Let me just get the reader. Maybe somebody will join in. Y'all can watch the replay. Standing. They must prove that they're the proper party. Standing is about who has the right to sue you. A debt collector must prove, one, that they are the lawful owner of that specific debt. Two, that debt was validly assigned to them. And three, the assignment includes the right to enforce. So when they are assigned the debt, they must also be assigned the right to enforce. They can be assigned the debt but not have the right to enforce it. And four, the amount is accurate and is supported by records. So the amount is normally on a billing statement, but it must be supported by records, which is a ledger. If they are not the original creditor, they must show a complete chain of assignment, not just a generic bill of sale. An example language that you can use for an answer in attacking standing as an affirmative defense is that the defendant denies that plaintiff has standing to bring this action. Plaintiff is not the original creditor and has failed to attach or plead a complete chain of assignment, demonstrating lawful ownership of the alleged debt. Plaintiff has not produced admissible evidence establishing that it is the real party in interest entitled to enforce the alleged obligation. Absent strict proof of ownership and assignment, the plaintiff lacks standing and the complaint must be dismissed. Short, direct, nothing else extra is needed. So, they must always prove that they're the lawful owner of the debt, that the debt was validly assigned to them, and that when it was assigned to them, it included the right for them to enforce it. And also, they must prove that the amount is accurate, which is the billing statement or the claim, which is supported by records. So, move on to authority. Authority is, do they have the legal capacity to enforce? So they must have the standing, then they must have the authority, the capacity to enforce. Even if they claim ownership, they must prove they are the licensed, authorized one to collect in your state if required. The person signing affidavits has personal knowledge. So you always want someone to be an agent with first-hand personal knowledge, which they really never have. And then the records are admissible under business record rules. So the way you will attack the authority as an affirmative defense is lack of authority. Defendant denies that plaintiff has demonstrated lawful authority to enforce the alleged debt or obligation. Plaintiff has not established that it is licensed or otherwise authorized to collect debt in this jurisdiction, nor that the individual executing any affidavit has personal knowledge of the account. Plaintiff is put to strict proof thereof. Burden of proof. So you, again, control the situation and you do it procedurally. 3, jurisdiction. Does the court has power over the case? Jurisdiction has 2 parts. Subject matter jurisdiction. Does this court legally have power to hear this type of case? Usually it's yes in debt cases, but you can challenge defects. Wrong court level. You can't take me to court because we have an arbitration clause, etc. Then you have personal jurisdiction. Does the court have authority over you? This depends if you was properly served, if you have residency in the state that the court is held, and according to contract terms. The way you would address that, which is ample language as an affirmative defense, is defendant asserts that service of process was defective and insufficient to confer personal jurisdiction. Absent proper service pursuant to applicable rules of civil procedure, this court lacks jurisdiction over defendant. So only if service was actually defective can you use this affirmative defense of lack of personal jurisdiction. If you wasn't properly served, they have no personal jurisdiction. That's the second part of jurisdiction. So you need to have a strategic mindset that standing is procedural leverage. Debt buyers often lack proper documentation to prove their standing and authority. And courts dismiss cases when plaintiffs can't prove ownership. You don't argue any of that sovereign citizen stuff. You just force them to prove. Judge thinks in terms of the evidence. Is it legit? Did they follow procedure? And did they fulfill the burden of proof? They do not entertain things like, I'm not the debtor. I'm separate from the corporate fiction. Or they have no contract with the living man. You're going to get ignored fast. And you can probably get sanctioned. And as they say, you will get railroaded because you're not following procedure. So you can put in your answer something like, the defendant denies each and every allegation, not expressly admitted. Plaintiff has failed to establish standing, lawful ownership, or the authority to enforce the alleged debt. Plaintiff is not the original creditor and has not provided a complete chain of assignment. Plaintiff is put to strict proof of the existence of a valid contract, the full accounting of the alleged balance, and lawful assignment of the debt, and its authority to collect within this jurisdiction. Absent of such proof, the complaint must and always will be dismissed. That's how you keep it firm and procedural. And also, have to remember, jurisdiction arguments are very state specific. So the way you will argue or do an affirmative defense against jurisdiction in Maryland will be different from how you do it in Virginia. It will be different from how you do it in Florida. It'll be different in how you do it in Texas because the civil rules of procedure are different. And standing attacks work best when it's tailored to the rules of your local court. So, Who is really the one that's allowed to sue? We talked about it, but we're going to reiterate it. Standing means you are the right party to bring this lawsuit. If you're not the original creditor, you must prove legally you own this specific account and have the right to enforce it. No proof equals no case. But if they are the original creditor, you need to say these things. Do you have the contract or the application? Do you have complete statements and accounting for the amount? And can you prove you are the account holder? So the way you would address original creditor is different from the way you would address a debt collector. So if they're the original creditor, do they have the contract or application? Do they have complete statements and accounting for the amount? So if they give you a bill, they must have a ledger proving that that statement, billing statement, is validated with a ledger. And can they prove you are the account holder? So in your answer, you will put defendant denies plaintiff has proven the existence, terms, and enforceability of any contract and the accuracy of the alleged balance. Plaintiff is required to prove the claim with admissible evidence. So when they file a claim and just attach a contract or billing statement, guess what? It's required for them to prove that claim with admissible evidence through someone with first-hand knowledge and a ledger. They must have the contract, the application, complete statements, and accounting. They have to prove all of this. But if they are not the original creditor, they're the debt buyer or the collector, you demand full chain of assignments. If it originated with A, then it went to B, and then it went to C, and then C is the one collecting from you, they must show each assignment and that it was properly done. The assignment must identify your account, not just a spreadsheet. Admissible records from the original creditor, not hearsay summaries like a billing statement. So in your answer that you will put to a debt collector is plaintiff is not the original creditor and has failed to plead and prove a complete chain of assignment and ownership for the specific amount alleged. Plaintiff is put to strict proof that it is the real party in interest, especially if it's a trust on you, and they are entitled to enforce the alleged debt. Now we go back to authority. Do they have legal capacity to collect and enforce? Authority means that even if you claim you own it, do you have the legal right to collect? And are your witnesses and affidavits valid? A company and its robo-signing doesn't get a free pass here. You need a live agent, a live living human being, man or woman, with first-hand knowledge to prove these things. If authority licensing looks valid, you have to go deeper to make sure it is valid. Because sometimes it looks valid, but it has weak points. Sometimes the affidavits isn't through personal knowledge. The records, business records, foundations, or hearsay can be attacked, and the fees, interest authorized by contract and law. So if they add extra fees and interest, is it authorized by the contract and law? Is these business records foundational or is it hearsay? Is this affidavit based on personal knowledge or not? That's how you attack authority, even if it appears that they have the authority. If they have a weak point, they do not have any authority. So you put in your answer, defendant denies the plaintiff has provided admissible evidence through a competent witness with personal knowledge to establish the alleged debt, its terms, or the amount claimed. Defendant objects to any affidavit lacking foundation. So, if it's questionable, this is where you raise these three things. They're not authorized and licensed. They're not registered to do business. And they're the improper plaintiff. They don't have the proper capacity. They're not the real party in interest. So, in your answer language, you can put this. Plaintiff is put to strict proof of its legal capacity and authority to collect and or enforce the alleged debt in the forum jurisdiction, including any required registration, authorization, or licensing, and of the authority of any affiant to testify to the court. Jurisdiction. It means that the court has the power to hear this type of case, but do they have the power over you specifically? If you wasn't service, they don't have power over you. Bad service equals bad venue. Well, I mean, if the service is bad and the venue is wrong, the court can't proceed until you've been properly served or they place this case in the right venue. So it doesn't automatically dismiss the case. It puts a halt to it till it's procedurally corrected. So, if service was proper, defendant does not waive any defenses and requires plaintiff to prove all elements of his claim. That's how you would do if you was proper. You make them prove everything. If the service was not proper, if you wasn't properly served, you could say the defendant asserts insufficiency of service of process and a lack of personal jurisdiction. Absent proper service pursuant to the applicable rules of civil procedure, the court lacks jurisdiction over the defendant. So, if it's a regular, normal debt case and you are in the right court, you can't contest the subject matter jurisdiction. But if something seems off, you need to do your research because you can be in the wrong court. Like, all right, do you supposed to be in small claims or do you supposed to be in civil court? And if they're trying to sue you as a debt collector, if your contract has the arbitration clause, you can bring that up because you can't go to court until you exercise all options in the contract, which is the arbitration. So in your answer, you would put defendant disputes that this form is proper and asserts that the claim may be subject to contractual, arbitration, and or other form selection terms. And defendant preserve all rights to compel arbitration or dismissal as applicable. So if you have in your contract a means to settle dispute and they haven't made use of it and you bring it up, you can't proceed in court. So, a universal answer that works, whether it's the original creditor or the debt collector, is that the defendant denies allegations except as expressly admitted. Plaintiff is required to prove every element of its claim with admissible evidence. Defendant disputes that plaintiff has established standing and real party and interest status. 2. Authority and capacity to enforce or collect the alleged debt. And 3. Proper jurisdiction and service where applicable. Plaintiff is put to strict proof of the existence and terms of any contract, ownership, assignment, a complete accounting of the balance, and a competent witness with personal knowledge. So, this is how you can proceed. If the plaintiff is an original creditor, you attack the contract, the amount, their identity, and if they give admissible proof, admissible evidence. If they're original creditor, you do not attack the chain.